a general intelligence test as a screening device for people who wanted to be police officers in Washington. Now, as it happened, for whatever reason, whether because the schools were bad or discrimination existed in the larger society, we don't know. But for whatever reason, it was turning out that many more blacks than whites were failing the test. And so a group of black applicants brought suit, saying that this is a form of racial discrimination, and it should be struck down applying the rules that apply to racial discrimination. It shouldn't be judged by applying the rules that apply to general social and economic distinctions. But the court said in that case, the mere disproportionate effect that a law may have is not enough to make out a case of racial or other invidious discrimination. What you have to show is that there is some purposeful discrimination. And the plaintiff in that case was unable really to show that. The police department didn't make a test that was racially discriminatory. It didn't pick out a test that would have those effects. It wasn't discriminatorily applied or graded or anything else. For the police department, it was just a straightforward neutral test, neutrally written, neutrally applied, and there was no purposeful discrimination that was actually at work in the case. And therefore, even though there may have been this disparate impact, the law was judged as an ordinary economic and social piece of legislation, not as a form of racial discrimination, and it was upheld. Now, you don't have to have real dramatic proofs that there's purposeful discrimination going on under the covers, so to speak. There's a case, for example, Arlington Heights versus Metropolitan Housing Development Corporation. In that case, the plaintiffs wanted to challenge a denial of a zoning permit to build housing that would be occupied by low-income residents, a majority of whom were racial and ethnic minorities. And they said that the denial of the zoning permit was racially discriminatory. But it didn't appear that way in its face. It looked like the government was applying regular zoning principles. And it certainly wasn't applied in that way in any obvious sense. But the court said this to the plaintiffs. Look, all you have to do is show that race was a motivating factor in what the government did. And if you can show us at least that, then we'll shift the burden to the government to prove that it was actually acting with non-discriminatory purposes. And if the government can't discharge that burden, then we'll look at this as a form of racial discrimination and judge it accordingly. Now, as it happens, in that particular case, the plaintiff was not able to show racial discrimination was behind the denial of the permit. And so the court went on to uphold this using rational basis review. But the point is, in order to establish a heightened review of a statute under equal protection on the basis that it's discriminating on race, alienage, gender, illegitimacy, or the exercise of a fundamental right, in order to get to the court to look closely at that law as if it were discriminating on any of those bases, it's not enough to show disproportionate impact. You have to show some purpose to discriminate on one of those bases. Okay, now as I mentioned before, there are these equal protection tests. And there are essentially 3 equal protection tests. And although these are not airtight tests, and although some justices like Justice Stevens have criticized the idea of having separate tests, and Justice Marshall has talked about having sliding scales, it's all along a spectrum, there are these 3 tests, and they do have certain characteristics, and the court tends to rely on them. Although the court doesn't rely on them slavishly, it tends to rely on them, and so you should use them as devices for analyzing equal protection cases. Okay, first I'm going to talk about the rational basis test. And you may recognize the rational basis test from our discussion under substantive due process, and in fact there's a great deal of kinship between the rational basis test here and the test under substantive due process. But let me note something at the outset. It is a very different question you're asking under equal protection as compared to substantive due process. In substantive due process, basically we're saying that the government is preventing you from doing something and that it's a violation of your liberty and the government shouldn't be able to prevent you from doing whatever it is you want to do, get an abortion, etc. And we said in the substantive due process area, if this inhibition on your liberty is in the area of ordinary economic and social regulation, rational basis applies. If it intrudes in the area of personal rights, marriage, family-type liberties, then we'll apply a compelling state interest test. However, in equal protection, it is a different kind of claim you're making. You're not saying that the government can't take a certain action at all. You're complaining instead that the government is treating people differently. So, for example, there's a case out of New York where New York City said that you couldn't have advertising on the side of your trucks as a traffic distraction measure. And if that's all that New York City said and you objected, you would be making a due process kind of a claim because you would be saying you can't do that. But in equal protection, you're saying something different. Now, what was actually happening in the New York City case is that New York City said you can't have advertising on the side of your trucks, but if you own the truck, making a separate class of people, if you own the truck, you can have your own advertising on the side of the truck. Now, the claim in that case was actually under equal protection. And what the plaintiff was saying is, well, maybe you can tell us that we can't have advertising on the side of a truck. But what you can't do is you can't treat groups differently and say that some can and some can't. Because as far as we can tell, if you're worried about distracting advertising on trucks, it's all the same. We all should be treated the same equally. So what you're really complaining about in equal protection is unequal treatment, and not the fact that the government is restricting what you're doing as such. Okay, let's look at the rational basis test. The rational basis test is what you should think of as the default test. It applies in all cases other than those 5 kinds of discrimination that I've identified: race, alienage, gender, illegitimacy, and the exercise of a constitutional right. So it's the default test that applies everywhere else. And what is the test when the government treats people differently in ordinary economic, social areas other than these 5 kinds of discrimination? Well, the ingredients of the test are as follows. The law is presumed constitutional. The burden is on the plaintiff to show that the law is unconstitutional. And the test is whether the law is rational. That is to say, is there any legitimate reason for the government to be treating 2 groups differently, to classify them into 2 groups and treat them differently? Now, any legitimate reason will do. Even if the government doesn't provide it, the court will supply it. The court will use its imagination and think up a legitimate reason why the government could act as it did. The law can be over-inclusive, that is, it can include more things than it should. It can be under-inclusive, not cover everything that's applicable, or both. So long as there is some connection, no matter how tenuous, between the classification that the law draws and the government's objective, the law will be upheld. Now, to show you how easy it is to satisfy this test, take the case of New Orleans versus Dukes. New Orleans passed an ordinance that said you couldn't have push carts in the French Quarter, in the historic French Quarter of New Orleans. The idea is that push carts were unsightly, that they really didn't look good in that area, they didn't fit in. However, the law also said you could have your push cart if you operated your push cart there for 8 years or more. In effect, it grandfathered people who had been there for a long time, and therefore it discriminated against